Mesdames et messieurs, chers collègues, chers amis.
Ladies and gentlemen, dear colleagues, dear friends, we've now reached the third and last session of the day. And before we go to the nitty-gritty, I'd like to make a few technical announcements. First of all, I would like to tell you that at the end of the panel discussion, a reception will be hosted by the Minister of Justice right behind this building. And it would be an opportunity for you also to see a concert and hear a concert. It's a very specific concert you'll see for yourselves. It will be a surprise. Let me also tell you that at the end of this meeting, we might forget if we don't mention it, tomorrow morning we will start at 9 o'clock. Now, for those of you who are in the former Yasmin Hotel, now called the Grandium International Hotel, departure will be exactly at the same time, at 8 o'clock sharp, as we said yesterday. 8 o'clock sharp to depart from the hotel to get this meeting. Let me tell you about the objective of this meeting, which is possibly to change the fates of migrant children in detention. Well, I think that that's our ultimate goal, isn't it? But for this session, my objective is much more simple. I'm just going to switch around the order of presentations, and I managed to do that. At least that's a success. So we will start with Mrs. Fiala. First of all, we'll hand over to Mrs. Fiala. Then we will continue with Mr. Silvestri, and we will finish with Mr. Xavier Créach at the end. First of all, I'd like to hand over to Mrs. Fiala. Doris Fiala, who's a Swiss MP. She's also, and that's, of course, something that she could be commended for, and all the Council of Europe would like to thank her for that. She's also the General Rapporteur of the Parliamentary Assembly of the Council of Europe campaign to end immigration detention of children. You have the floor, madam.
If one has seen what I have seen, ladies and gentlemen, in all those detention centers, I would say you lose your innocence. Thank you, Mr. Giakoumopoulos, for giving me the floor, Minister Pelikan, Commissioner Muchniek, Special Representative Bocek, ladies and gentlemen. It is my great pleasure to represent the Parliamentary Assembly of the Council of Europe at this international conference, kindly hosted by the Czech chairmanship of the Committee of Ministers, who I congratulate for this very important initiative. The fact that we are meeting here today to discuss this extremely important topic, it is a clear sign that the awareness of this very negative practice of immigration detention and its impact has finally been raised. When the Parliamentary Assembly of the Council of Europe addressed this issue in the report on the alternatives to immigration detention of children in 2014, the opinion of the international community in general was far from the consensus that we have today and completely stopping and detention of migration children. Since then, there has been a number of changes in the right direction in Europe, and this high-level meeting is a clear sign of the positive development in this respect. We heard this morning the terrible first-hand experience of a formerly detained migrant child, Pinar Aksu, who has become herself a greater supporter of our campaign, and I thank her very much indeed for that. Dear colleagues, many of these children, unfortunately, cannot testify on what they have experienced. As a rapporteur on this matter, I have seen many detention centers, I just told you at the beginning, and I was deeply troubled by their conditions. We cannot underline enough how vulnerable these children are, arriving without their parents relatives, or even friends, without documents, completely alone, and after an exhausting and traumatizing journey from their homes, fleeing war and violence. Many of these children have already suffered violence, physical, sexual, you name it. In many cases, they are also victims of human trafficking. The last thing they need is to be detained in places like prisons, where they are not only deprived of their freedom, education, and health care, but moreover, they risk being abused. They are detained with unrelated adult men behind bars, and this I have seen with my own eyes, and that was really a motivation to fight against it. The only reason for this detention is that they don't have the right immigration documents. As a response to this situation in April 2015, the Parliamentary Assembly launched a campaign to stop this practice and to promote alternatives to the administrative detention of migrant children. In its resolution 2020, the Assembly recalled that unaccompanied children should never be detained. Moreover, it stated that the detention of children because of their or their parents' immigration status is contrary to their best interest, and it is child's right violation, notably defined in the Convention on the Rights of the Child. On this occasion, the Assembly also called governments to adopt alternatives which allow children to remain with their family members or guardians in non-custodial, community-based contents while their immigration status is being resolved. The parliamentary campaign is based on this resolution and implemented by the Assembly's committees on migration, refugees, and displaced persons. We are aiming to change national legislation where detention is still allowed, but also to change policies, as in many cases detention is not permissible by law, unfortunately still used in practice. But we cannot do it without your help, ladies and gentlemen, and without your personal determination. Since its launch, the campaign has been supported by nearly 1,000 parliamentarians, representatives of national authorities, civil society, and the international community who have signed the petition to end immigration detention of children. The President of Malta, Mrs. Marie-Louise Colero-Preca, and the President of National Parliaments, Mrs. Christa Markwald, my colleague, then President of the National Council in Switzerland, Mr. David Usupashvili, then Speaker of the Parliament of Georgia, Mrs. Maja Gojkovic, Speaker of the National Assembly of the Republic of Serbia, Mr. Miran Berglec, President of the National Assembly of Slovenia, and Mr. Faisal El Fayed, President of the Senate of Jordan, have all supported our cause. We are also grateful to the social representative of the Secretary General on Migration and Refugees, Mr. Tomasz Bocek, for his constant support to the campaign. Thank you so much. In our campaign, we use a range of methods and activities as we work towards stopping this harmful practice. Firstly, we are focusing a lot of awareness raising among parliamentarians. We are regularly organizing discussions with top experts on the matter who are passing their knowledge and experiences on the members of parliament. We have met with psychologists and legal experts with whom we examined the long and short-term consequences on a child's physical and mental health. Very important are the testimonies for formerly detained migrant children, and in this aim we had several so-called living libraries, organized in the Council of Europe, where parliamentarians can borrow a living book and exchange tête-à-tête with the person on his or her experience. Such discussions, ladies and gentlemen, can be awakening as we hear the horrors of refugees' paths. On the other hand, we continuously exchange views, expertise with UNHCR, OHCHR, and NGOs on viable alternatives. One of the serious issues that was discovered during the work of the campaign is the lack of up-to-date statistics on how many children are actually held in detention. Within our campaign, we conducted a study, Immigration Detention of Children in the Council of Europe Non-EU States. EU Fundamental Rights Agency published a report on the situation in EU countries. I hope Mr. Adriano Silvestri will probably speak about that afterwards. As said, obtaining data from states on the number of children placed in administrative detention is extremely challenging, and this is something that should be addressed in the future. One of the main findings of our study and issues of concern is that examined states lack child-specific legislation in the area of immigration detention and particularly alternatives to administrative detention, but also screening for the identification of vulnerable children which need specific protection. We are organizing parliamentarian seminars in member states to discuss the country-specific legal and policy framework. The meetings organized in the Netherlands and Switzerland last year were a big success in the term of excellent attendance, including by high officials from the ministries in charge of immigration. We had very fruitful exchange with the national representatives who expressed a high interest in the topic. These hearings aim to identify and exchange good practice and not, ladies and gentlemen, not to blame and shame. Since recently, we also extended our target group to national ombudsmen, as we have a joint action with the Council of Europe's Children's Rights Division. We are organizing trainings on monitoring detention places where children are deprived of liberty because of immigration policies. These trainings are based on a parliamentarian guide that was produced in the framework of the campaign that will soon be published. In parallel to the work on the monitoring, we are also looking to explore viable alternatives on the spot, which already exists in some countries. I want to stress that there are good practices which should be promoted so as to encourage other regions and countries to adopt such models. It is interesting to note that quite often immigration policies towards migrant children differ not only between states, but also between regions in the country itself. Such an example is my own country, Switzerland, where the link between the asylum system and the protection of children and adolescents is not regulated at federal level, so the cantons have different systems, which makes it, you can imagine, very difficult. In March this year, we visited one of the residencies for unaccompanied minors in the canton of Bern, which was an excellent example of care and accommodation for migrant children. During such visits, my fellow parliamentarians and I could see firsthand the different programs for migrant children which respect their liberty, offer them schooling, and prospect for the future. Ladies and gentlemen, I'm very upset to say that the population of Switzerland, of Bern, and you know we have a direct democracy and people go for a vote very often. So in this case, Bern voted recently against the budget to continue the program of this specific center. Another topic of the campaign to which we arrived in the course of our 2 years' work is the urgent issue of the controversial ACE assessment. We have already been talking and hearing about it lately. I believe that this topic was brought up in one of the thematic sessions, and I'm not yet sure that what will exactly happen in Bern, but I do know that we must go on with what we have been started. During our parliamentarian seminar held in Bern last year, we launched a debate on this extremely important topic. Upon their arrival in a country, if they don't have identification documents, unaccompanied children have to go through age assessment procedures so as to determine whether they are indeed minors and hence entitled to specific protection. I can tell you that it was shocking to learn that in a number of European countries, unaccompanied minors are subject to invasive and degrading procedures to determine their chronological age. Very often, these children are proclaimed adults and excluded from child protection care and put in detention. I am currently working on a report on this topic in the Committee on Migration and hope that very soon the Council of Europe will be able to develop standards on child-friendly age assessment, which will be respectful of a child's age and dignity. And this must be a holistic approach. In conclusion, it is obvious that much more work remains to be done on the European, but especially national level, so as to end these damaging practices and truly explore alternatives that are still insufficiently used. In this view, we are looking to prolong our campaign for another year and to focus particularly on promoting viable alternatives and child-friendly age assessment. I would stop here in order and leave you the time for discussion, and I would warmly invite you to pass by our campaign stand, which is just outside of the meeting room on the left. Please take a look at the various videos, material and documents available there so that you can get further information on all our activities. It is also, I also invite you to support the campaign by signing our petition to end the detention of migrant children. By giving your support, ladies and gentlemen, you will help us in fighting for this cause and pushing for the rights of migrant children to be respected. Also, I warmly invite you to talk to me or my colleagues from the Assembly Secretariat on how you can contribute to the campaign. I thank you so much for your attention, and I call upon you, ladies and gentlemen, we are all in a common boat of responsibility. The child's best interest is our common best interest. If all risks are global, terrorism, radicalization, migration and refugees, it is only together that we can find answers and prevention. Let us act together. Detention of children has a terrible impact and concerns all of us. Thank you very much.
Thank you very much, Mrs. Fiala. We're very happy to get such commitment. We're not always used to that. I would like now to hand over to Mr. Silvestri, who's a colleague from the Fundamental Rights Agency of the European Union. He's going to talk about the report that was produced by the Fundamental Rights Agency regarding the detention of immigrant children. Over to you, sir.
Well, thank you very much, distinguished panel, distinguished participants, colleagues, friends. First, before I start, I really would like to thank the organizers, so the Council of Europe and the Czech chairmanship, for having organized this event now. It is extremely timely. it's part of a series of activities in this area relating to discussing whether immigration detention of children is a policy tool that can be used or not. But it also comes at a time where, from an immigration law enforcement point of view, the immigration detention of children is increasingly seen as a necessary tool in Europe. So I think it's extremely helpful to have this discussion now. What I will do is, and first let me see if I'm able to use this. Yes, what I will do is basically to speak about this report, which I realized I brought in 2 little copies, although I had a full suitcase, which was very heavy when coming here, but which is available and can be ordered from the FRA web page if you are interested in it. We have many copies available. This is a comparative report that illustrates very much what the role of the Fundamental Rights Agency is. I mean, our primary goal is really to take a picture on what happens in the member states on a particular issue and analyze the findings in light of the EU fundamental rights law framework. This to provide the EU institutions primarily, so the Commission, the Parliament, the Council, but also member states, with what we call evidence-based advice. So suggestions on how policies should be implemented or applied, which are respectful of fundamental rights, which are not just based on our own analysis sitting in Vienna, but which are based actually on what happens out there. I'd like to build, to start with, on the presentation this morning by Margaret Tweed from the European Commission, who provided an overview of the EU legal framework concerning immigration detention of children. She spoke about detention in the asylum context and detention in the return context, or for the purposes of return. Just to flag 2 additional documents which I think are important to be aware of. And these 2 documents. They date, one is of March this year, and the other is of April this year. The first one being essentially an effort by the European Commission to encourage member states to make returns more effective. And there are a number of recommendations in there that concerns the effectiveness of returns. But there is also a point in there which was somehow raised this morning indirectly in the discussion, which basically, well, maybe I should read it out, in fact. I mean, it basically says that in respect of the fundamental rights and of the conditions set by the Return Directive, member states should not preclude in the national legislation the possibility to place minors in detention, where this is strictly necessary to ensure the execution of a return decision, and when other alternative measures or less coercive measures cannot be applied effectively. So we have here an illustration of what I mentioned before, an attempt to respond to the concerns that are expressed at member state level, that immigration detention of children is needed for a proper functioning of a return system. The second document which I wanted to mention is a communication which speaks to the same issue. It's a communication of the protection of children in migration in general, but speaks also to the issue of immigration detention, and basically says that detention, so given the negative impact of detention on children, administrative detention should be used in line with EU law, exclusively in exceptional circumstances, where strictly necessary, only as a last resort for the shortest time possible, and never in prison accommodation. The reason why I read out these 2 documents is that it shows the tensions that are out there today, and that makes this event, I think, particularly important. I mean, just to summarize in a way how would I say, the core lines of EU law on this field, I mean, immigration detention of children must be really exceptional, only where strictly necessary, which means that alternatives must be available and accessible also in practice. I'll come back to that. EU law speaks of the shortest time possible and never in prisons. This was an introduction. What I would like to move, however, is more the report itself and some of the findings of the report itself. First, we wanted to collect statistics on children in detention. We utterly failed. First, we tried to collect them to try to find out from member states how many people they detain in a year. No chance. Then we adopted another approach. We collected on, I think it was 6 dates, if I may remember well, the number of children in immigration detention on that specific day in the 28 EU member states. Not everybody replied, and some replied for some requests, some replied for the other requests. But what we got is at least some indication about the, maybe not the prevalence, but an indication about numbers of children in detention, which basically show that it is not really exceptional, first of all. I mean, among the member states that we got feedback, I think there were only 2 member states, if I remember well, who basically throughout said that there were 0 children in immigration detention. So the majority of member states had children in detention, and some 11, I think, member states had more than 10 children in immigration detention at one of these dates. In some cases, far higher than 10. So the second thing I wanted to mention is that although it's not only exceptional, and it recurs regularly, it is also not a huge number of people in detention. I mean, maybe if we look, it's numbers for which I think solutions or other solutions could be found. If we put aside the situation on Mayotte, this overseas French territory in the Indian Ocean, which itself has more children in detention than the rest of the European Union altogether, the numbers, I think, are manageable. And the spirit under which this report has been written is really that we believe that the immigration law enforcement objectives, meaning enforcing returns also for families where necessary, or preventing onward movements, irregular onward movements of asylum applicants from one EU member state to another, can be achieved by and large also without resorting to detention. I mean, we believe that by building a system that really takes the protection and care of children at the center and focuses on the social aspects rather than on just the use of the stick. So case management, counseling, alternative housing, better communication, that it would be possible to manage a system with absconding rates which would not be lower than what we have today. So this is the logic under which we wrote this report. The report itself is structured essentially in 8 blocks. It has 2 general blocks setting out the right of the child to protection and care and the right to liberty and security, and then goes into 5 maybe artificial aspects, because in a way they are all interlinked, but 5 blocks that need to be ticked in order to make sure that detention or deprivation of liberty is not arbitrary and not unlawful. So we first look at the legal basis in national law. We look at the grounds which are allowed under the grounds for detention allowed under law, under national law, necessity and proportionality, procedural safeguards, and finally, detention conditions. The last chapter then is devoted to oversight mechanism, an extremely important aspect. So now what are some of the findings. I'll start off with the first box, which is the legal basis in national law. Out of the 28 EU member states, and FRA has a mandate only to look at European Union member states, not at other countries in the EU, even if those other countries, like some of the Schengen-associated countries, are bound by some aspects of, or by the EU law provisions that we are speaking about. So if we look at the legal basis for national law, there is only one state or one member state in the European Union that does not allow immigration detention of children, and that is Ireland. For the rest, all other member states allow it in some circumstances. However, if we move to detention of unaccompanied children, we see that the picture is different. Around half of the member states do not allow detention of asylum-seeking children who are alone, who are not with their parents. I mean, in some cases, this is clearly forbidden by law. In other cases, the law is, I would say, vague. An example is Portugal. There are general provisions that provide for the care and protection of unaccompanied children, and these are interpreted as essentially prohibiting immigration detention. So this about asylum-seeking children. If we move away from asylum into return, we see that the picture is a bit different, but again, not so different. Roughly 1/3 of the member states do not allow unaccompanied children, and again, this is only about unaccompanied children, to be deprived of liberty for return purposes. Germany features in the map as a country where immigration detention of children for return purposes is in principle allowed, but there, in fact, the situation is different from one land to the other. So this about the legal basis. So what we can see is that there is as concerns state practice, there is a considerable difference between children with families and children who are alone. When we look at the permitted grounds, I mean, they were listed this morning by a number of speakers, but I thought it maybe be useful to compare the grounds under EU law, so the grounds that are envisaged in the Reception Conditions Directive, the Dublin Regulation, and the Returns Directive, with the grounds under the European Convention of Human Rights. So Article 5.1 and 5.1f more specifically. I won't spend a lot of time here, but there are two questions for the lawyers in the room that we are struggling with. One is the detention under the asylum acquis to basically determine or verify the asylum seeker's identity, and the detention to determine the basic elements of the asylum claim, where I see a tension between EU law and the European Convention of Human Rights, particularly given the fact that the EU law provides for the right to stay in the European Union once that a person applies for asylum. So in that sense, that the application of the first part of Article 1.5f, so to prevent an unauthorized entry of a person who has a right to stay, even temporarily, in the country, seems a bit difficult. The second element is the ground in the Reception Conditions Directive that relates to public order or national security and public order. Also that I find some difficulties to link with the European Convention of Human Rights. On the third box that I showed at the beginning, so necessity and proportionality, here I would just like to focus on one issue, as this is going to be discussed much more in detail tomorrow. And this is alternatives to detention. For two reasons. One, just to remind that some time ago, FRA published on its website a sort of guidance on the use of non-custodial measures for asylum seekers and for people in return procedures, but also to ask a question, which really is, what can we do to build in the EU today systems of alternatives to detention that are used and that can function also from a member state perspective, that can also fulfill the requirements that member states in charge of enforcing immigration law would like them to fulfill, which means a certain degree of how would I say, a migration outcome at the end which is respected. I mean, what we see is that there are very few examples of or let me start the other way around. Alternatives to detention are conceived in the very traditional way, the bails, the residence restrictions, but there's very limited effort to try to engage beyond small pilot projects, more systematically with an approach that would put at the forefront social work, engaging with the migrant or with the asylum seekers and trying to make him or her part of the migration decision related to him or her. The second thing, and that's also a question maybe for the panel tomorrow, when we had, after presenting the report, a meeting in Vienna with primarily ministries of interior in charge of returns, one concern or one view that was expressed by the colleagues from the Ministry of Interior that were there is that we need the possibility of detention as a stick in order to be able to use the alternatives. We've seen that in the Netherlands, we see it in Belgium now with the change of legislation. So I think that's another interesting element for the discussion tomorrow to reflect upon. Just very briefly, two last points on the two last boxes of the 5 boxes, so to speak. One on the child, on the procedural safeguards. Of course, when you detain or when you decide to deprive children of liberty, there are additional procedural safeguards you need to respect. One of it are child-friendly procedures. I'd like for 1 minute just to share the example or the practice in Utsano. This is the Finnish facility where children with families are detained, where the migration authority, or rather the judge who prolongs the detention or approves the detention, has to hear or has to see a report by the child protection, the local child protection authorities before the judge can decide on whether to prolong the detention. But then, of course, child-friendly information, a big gap, and guardianship, which was just touched upon in the last panel, and where, from our point of view, an important key to address immigration detention of unaccompanied children lies. If we see, I think Greece was mentioned a couple of times here, and the numbers of, or the situation of detention in Greece. But when you speak then to, or I think there was also a case mentioned of a minor, an unaccompanied minor detained in a police facility or police office in Greece. But when you speak to the police officer who is actually in charge of or who is detaining the child, his main concern will be, if I let this child go, I will face criminal procedures because the child will be missing and I will be responsible. If a system, if a functioning guardianship system were in place, where certain responsibilities are not anymore with the frontline police, but there where they should be, that could be avoided. Finally, my last slide, just to provide some overview of facilities which are used for the detention of children. We asked essentially member states to identify and report to us the facilities that they consider that are adequate for depriving or for holding children together with their families, as well as those facilities which are adequate for holding children who are unaccompanied. The report contains a list of 39 facilities where authorities consider that families with children can be held in 19 EU member states, and there are 25 facilities where unaccompanied children can be held. As you can see from the list, this FRA did not assess whether these facilities indeed are child-friendly or not child-friendly, and you can see on the list some of the facilities which have been largely criticized. But nevertheless, we thought it's important to at least share which are the facilities that are considered to respond to the requirements of the Reception Conditions Directive or the Return Directive by the member states involved. So I hope this overview can be helpful for the further discussion. I stop here and of course available for any further questions. Thank you.
Thank you very much, Adriano, for this overview, and indeed you step back, and I believe that this in fact highlights the tension which everybody has described between the practice and existing law on the one hand, including national practices, and on the other hand, the wish to go beyond this problem, to overcome these problems and these practices which are developing at international levels. I'm not going to comment on all of this right now, but I would now like to give the floor to Xavier Créach, who is now going to talk to us about what he wants. But I would just like to say that Xavier is in charge of the Department of the High Commissioner of the United Nations for the Protection of Europe.
Thank you very much. I'm also hesitating to go on with French, no? But no. Thank you very much. Thank you, first of all, to the organizers. It has been very impressive, I found today. Even if the weeks before, you know, we could see the build-up of the conference, the information coming. So thanks a lot to the Czech Ministry of Justice, to the Council of Europe. There is one thing for which I may not thank them, is to give me the last presentation of the day. And I was wondering, how do I do that? There is already 17 experts, who are real experts, who have said many interesting things about detention, probably much more interesting than what I could say. And where I'm a bit an expert is more an alternative to detention, but it's tomorrow. So with the authorization of the organizers, I've decided to speak about something else. Of course, something links to detention, with a bit the idea, what happens if really detention comes to an end? If it does work, if children are not detained anymore, is it the end of the problem? So I will try to speak about that because it's based on our personal experience. As you said, I'm the head of the production unit for Europe, meaning I'm in charge of helping UNHCR operations in Europe to develop an operational response. And when you try to develop an operational response on detention, you discover that detention is a problem among others. And if you isolate detention from the rest of the problem, you don't find a solution to the problem. We have been HCR working on the question of detention of children around three main areas. One, I think, is known to you, to most of you, and if not, you will find all the documentation in the USB kit. It's called the Beyond Detention campaign. It's a strategy that UNHCR has been implementing now in 20 countries around the world. I won't say much more because part of it will be covered tomorrow morning in the alternative to detention session, but in addition, all the documents are in USB kits or hard copies are available in the room. We have also worked with UNICEF on what is called the roadmap for child protection in Europe. So basically, a part of our work has been advocacy on this issue. Second one has been what we call strategic litigation. We have intervened in various cases, and again, very recently, in front of the European Court of Human Rights in a third-party intervention, specifically on the question of detention of children. And the third one is to operationalize alternative to detention, to help government day-to-day to find alternatives. And we'll focus on the difficulties we have faced and we have realized. Many of you have taken the example of Greece, so I will do the same. In Greece, there is a concept which is called protective custody for children. Children are detained to protect them. That's what the law is about. And working closely over the last years with the prosecutor, with the Greek authorities, but also with the Greek civil society, alternatives have been found. Now, there is 1,100 rooms, beds, for unaccompanied children in Greece. 1,100 is quite a lot. The problem is that there are 2,400 unaccompanied children identified in Greece. And the problem is that even when you find an alternative to detention to them, the kids are on the move. Children are on the move, like the rest of the world. And they're on the move because they have good reason to be on the move. They're on the move. We did survey of 1,000 Afghan unaccompanied children in Sweden. We did survey of Afghan children and Syrian children in Greece. And they have three main reasons to be on the move. One is to reunite with their family. They want to join their dad. They want to join their mom. They want to join their brothers and sisters. And they have the right to do it. So if you find an alternative to detention in Greece, but the parent is not in Greece, you have not found a solution to their problem. Second reason for them to be on the move is to have access to education. If we look at the number of children in Greece, like elsewhere in Europe, who have access to school, asylum seekers, refugees, it's extremely low. In some EU countries, in 2016, we had sometimes a rate of enrollment to school below 10%. So if the kid cannot have access to school, what do the parents do? They send him in another country. So you may have found an alternative to detention to him, but you don't have found a problem to his access to education. And the third one, even if there is no right to choose your country of asylum, I would like to take the example of an Afghan kid in Bulgaria. Do you know what is the recognition rate of Afghans in Bulgaria? It's 1.7%. The average in the EU is around 48%. In Italy, it goes up to 91%. Try to convince an Afghan unaccompanied kid to apply for asylum in Bulgaria and to stay in Bulgaria. You will never be credible. He knows. If I stay here, I will be rejected. And if I'm rejected when I'm 18, I will be detained. And if I'm detained, I will be deported. So these kids, either if it's for family reunification reason, either if it's to have access to education, or if it's to be granted protection, will keep moving. And when they keep moving, what happens? They are exposed to enormous protection risk. Detention is one of them, but there are others. You know that what is the country receiving the main number of unaccompanied and separated children in Europe in 2016, 2017 was Italy. And where they were coming from? Central Mediterranean route. 90%, 90%, it's not my French accent, it's 90% of the kids who have arrived to Italy are unaccompanied and separated kids. They have put their life at risk in the Central Med. We know how many people have died in the Central Med. We don't know how many kids, but it's very hard. Kids die on railway tracks. They die in trucks. So high risk for the children while they're on the move. It's one of the other huge problems we have to look at. Second one is that even if they are not exposed in danger while on the move, while crossing border, they are exposed to danger where they are. Sexual work is a very sad but reality in Europe. In many of the parks of the various capitals in Europe, you find Afghan, Syrian, asylum seekers' children prostituting themselves. And very often to what? To find the money to pay the smugglers to go and see their family. So we are back to the same problem, family reunification. I could add to that. I'm sorry, I'm getting lost. I got passionate about it, and then I got lost. Third problem. We always think that kids leave their country of origin unaccompanied or separated. Many of the family separation happen during the route. When you cross the border at night, in the mountains, in the green border, you're with a smuggler, a trafficker, a group of 40, 60. The police intervenes, everybody runs everywhere, and who are the only one left behind? The small kids, sometimes babies. They don't even know their identity. They don't even know where their parents wanted to go for. So what I'm trying to say here is that the solution to the question of detention of the children can only be part of a broader solution to child protection in Europe. Even if our campaigns, the Council of Europe campaigns, UNHCR, what we do with UNICEF, was fully successful, kids would still be exposed to tremendous protection risk in Europe or outside Europe. That's why we tend to believe that the only way to sort out this problem is to further develop and work on what is called legal pathway, meaning permitting kids to join their family members or to reach protection in a legal way, not depending on smugglers, not depending on traffickers. When an unaccompanied child has a legal avenue to reach Europe, the question of detention is not even asked because he reached legally Europe or because he moves within Europe legally. And this is two aspects I would like to detail in the 10 minutes with some very concrete examples because they are very positive developments. And as you said, we are not going to only criticize, we're also going to flag the positive developments. You all know that in Calais, what was called the jungle was dismantled. Was it last year, 2016? I think it was last year. When it was dismantled, and all the kids there, they wanted one thing, to go to the UK. And to go to the UK, they were exposing their life every night, or every 2 nights, or every 3 days, with smugglers on railway tracks, fences, etc. We found, when I say we, I don't mean HCR. I mean people working with the kids. In particular, I would like to mention one, which is Citizen UK, who have a specific project which is called Legal Safe Passage. They found, at the moment where the jungle was dismantled, 700 unaccompanied and separated children who had the right to go to the UK. These kids didn't even know. All the people who had worked there for months with them didn't know. And these 700 kids have traveled legally to the UK. 700 out of 1,800. So it's not a solution for everybody, but it's not either a solution for 2%. So there are pathways. The problem is that they are very complex to use. And I would like to give you an example. Because now we work with Citizen UK in different countries. I will give you another example. Italy, 25,000 unaccompanied and separated children arrived to Italy in 2015. 28,000 arrived to Italy in 2016. Do you know how many of these, so 53,000 kids, have been reunited to their family under Dublin? 0. 0. Not one. Not one until August 2017. In August 2017, the same methodology that in Calais has started to be implemented in Italy, not only towards the UK, but also now towards Germany and towards Switzerland. And the first 14 cases in only 1 month have already been identified and are on their way, who have already been reunited with their family. So what I'm trying to say is that there is not legal pathway for everybody. There is not a solution for all the kids. But there is one already available for many. The problem is that a kid will never be able to use this pathway on his own. One example, if you look at Greece, if you look at children, how would they call it? Request for family, no, I have the word. Well, family unification transfer under Dublin. The Greek authority have an acceptance rate by other EU countries of 20%. When the Greek authorities do it on their own, 20% only of the requests are accepted. When this methodology of Citizen UK is used, the rate of success is 95% for the same cases. I give you an example. A kid tells you that his dad is called Mohammed. Do you know how many spelling there is of Mohammed in the Schengen information system or in the Eurodac database? 21. Mohammed can be spelled 21 different ways according to what we already have. So if you make one mistake in the letter compared to the way the dad was registered, you never find the dad. And you come to the conclusion that the kid has lied, that the father is not in Europe, when it's just a spelling. Imagine, we're talking about a name in Arabic alphabet, translated in a Cyrillic alphabet, Greece, and then from the Cyrillic alphabet in a Roman alphabet in a database. I'm not exaggerating here. So imagine the probability to have the kid spelling the name of his father in the right way. So if there is not someone to sit with this kid and to spend hours in the database to try to find with the 21 possible spelling the dad. Because of course, in most of the cases, the kid doesn't know the date of birth of the dad. No, that's, of course, if we had other biodata, we do not need that. So this kind of very concrete, problematic, can make a huge difference and are making a huge difference for these kids. It's not the only way, no? There is also lots of court case. Sometimes you have to go to court to oblige the government to register an asylum claim, because without an asylum claim, there is no Dublin transfer. So if a kid is blocked on a Greek island or in Sicily or elsewhere in Europe for months and months without registering the claim, then he cannot be entitled to Dublin transfer, no? Sometimes it's a question of establishing the family link. Sometimes it's even a question of a DNA test to prove that. It's impossible for a kid to do it on his own. There must be someone, an NGO, a civil society, a government, a lawyer, to help him. So what I'm trying to say here is that advocacy campaigns are super important. We need to go and to go with this campaign with also operational support, because there is these possibilities. So you see now, I've spoken mainly about transfer within Europe. I still have 4 minutes, so I will speak about from outside Europe. I would still like to say that since Citizen UK Safe Passage Project started to work, it's 1,100 kids who have been legally reunited with their family in the last 3 years. No? So it's not nothing either. I know the figures are much bigger, but it's very important, because the more you demonstrate to a kid or to a community that there is a legal pathway, the more you build the trust with them, and the more they are ready to come to you and to try their chance. No? So every time a kid is reunited with his family, it's 5 more who shows up, and et cetera, et cetera. That's why the figures remain low, but they are still very helpful. Now, I have been talking so far only about family unification within Europe. I said from France to UK, from Italy to Germany and Switzerland, from Greece to elsewhere. It still means that they have to reach Europe. It still means they have to be exposed to tremendous risk. So what we want is that this legal pathway exist either from the country of origin or for the first country of asylum. And here I would like to use a huge example. We know how central Mediterranean route has been the focus of all the politician leaders' attention in the last weeks or months. We know how everybody is looking at Libya. Where are the people coming from Libya from? They come mainly now from West Africa. There are two main countries of asylum in Africa, in West Africa. One is Niger. In Niger, there are 250,000 refugees without a durable solution. Do you know how many of them have been resettled to a third country last year? 5. 5 out of 250,000. I'm not exaggerating, no official data. Chad, 100,000 refugees. How many have been resettled? 1. So the message we pass to these refugees in Chad and in Niger is that there is no option for them. There is no legal way to reach protection, to reach their family. They have to go with smugglers. They have to go with traffickers. And we come back to the problem of detention. That's why we have been trying, and it has been largely used by some leaders, we have been trying to work in the detention center in Libya. With some success, small success. But for example, HCR, over the last year and a half, we could negotiate, it's difficult negotiation, that 1,045, what we call person with specific needs, basically it means unaccompanied children, pregnant women, women out of household, be released from detention. So they have been released from detention in Libya. But then what? What do we do with them? We don't even have the right to have a reception center in Libya. What we have are 2 secret safe houses for a capacity of 50%. So if we get these people to be released, they're back in the street of Tripoli or elsewhere, meaning they're back to the smuggling trafficking networks. And it's very likely that a month later, we'll find them again in a detention center. And I don't even mention here the, the standards of the detention center. So we have been promoting the establishment of what we call an emergency transit facility, precisely in Niger, but in other countries. We're also looking at Chad, at Burkina Faso, so that precisely we can allow refugees and sometimes migrants who have other protection needs to go legally to the EU. And we do believe that's the solution to detention. For that, I would like to finish with that, just to show a bit where we are sometimes in a kind of hypocrisy. We have asked the president of Niger the authorization to open this facility. He gave us a pre-agreement, but he said, one condition, I want a firm commitment from Europe with figures that they will accept these people. What does Europe say? The EU Commissioner supported. The EU Commissioner supports HCR requests to 40,000 places. But beyond that, we don't have a country who say, I'm ready to take 55 tomorrow. So the president of Niger said, well, HCR, until you have this very detailed figure of where they will go, you can't open the center. And what does Europe say? Well, until you have a center, you don't need a figure. So you see, and for the time being, this results in children, using smugglers, very often ending up with traffickers, and then we see them in detention centers. Thank you very much.
One of the questions that have been put to you, Xavier, says, thank you for urgently emphasizing the bigger picture of the failure to protect migrant children. So I think that this is a good conclusion for your presentation. Now I would like to perhaps give some perspective in what we have tried to do, because I think that we have a rather accurate picture of the status of law, although we do not all agree whether the law prohibits or does not prohibit migrant detention of children. I think that it is clear that we can say that there is migration detention for children is widely practiced in Europe, and that it is also clear that there is no clear prohibition of it. It is perhaps not allowed, but there is no clear prohibition either. And in international law, again, I would say that whereas soft law is more or less clear, treaty law, at least primary treaty law, is pretty much unclear, and that despite the several positions that have been taken, both by comments of the Committee of the Rights of the Child, by the High Commissioner for Human Rights of the United Nations, by the Commissioner for Human Rights of the Council of Europe, or the Special Rapporteur of the United Nations on the rights of migrants, who are quite clear on that. The Parliamentary Assembly of the Council of Europe. So what does it take to change this situation? What does it take to make national parliaments, national governments, the EU also, understand that this is the trend, that there is micro-detention for children should not be allowed. How to make the question mark from the title of our conference disappear. And I think that what we looked into today, the campaign in this part, the clear report that the Fundamental Rights Agency has made, and also the overall context in which Xavier has placed our discussion are helpful to try to find ways to remove the question mark. So the floor is yours. Before we move to the specific questions that have been asked. S'il vous plaît.
Well, talking about the Council of Europe, shouldn't we use Article 19 of the Social Charter? Article 19 talks about the protection and assistance to the migrant workers and their families, with the possibility of a collective action that is possible. We are the International Conference of NGOs, and we will have to see whether we can't have collective claims as per Article 19 of the Social Charter. We talked about family reunification. Shouldn't we also work on the issue of humanitarian visas? We have the example of the Protestant Association and other NGOs. They're working on securing humanitarian visas, in particular from Lebanon, with France and other countries as destination countries. Isn't it a possibility? I mean, especially for vulnerable persons who might want to take up a job. And we were talking about the children who might be detained so far, but what about the children who are homeless, who are out in the street? Shouldn't we do any work to protect them? And as a Frenchman, I must say I'm not very proud of what's happening in Mayotte. In Mayotte, where we have Comorian mothers who come to give birth in Mamoudzou, in the capital city of Mayotte. It's the biggest maternity ward in Europe. 9,000 children are born there every day. And when the mothers are detained by the police, they don't say that their children were born in Mayotte. They don't say that because they hope that they might become French nationals. So we have 6,000 or 8,000 children living in the streets, and they try to really, survive. And the authorities in Mayotte will be, fed up with all these kids living in the streets. I'm sure there's some work to be done here to help the street children in Europe too, not just in Bogota, but actually in France, in Mayotte, it's happening. Thank you very much for your comment, for your question, which is really of the essence. First of all, I would like to give you an answer as regards the humanitarian charter of the Council of Europe. My answer is not an excuse. Think about this. Everything we do at the Council of Europe, all the conventions that we come up with, even the humanitarian charter, this doesn't mean necessarily that it will become law in all 47 member states. So every convention has to be voted upon, has to be ratified in the country in question for it to be applied. So it doesn't become law automatically. So it's not that I'm proud of that. I would love to tell you that Switzerland has not yet. I would have loved to say that Switzerland has already signed the humanitarian charter, but it is not the case. And I can tell you why it is that we haven't yet signed the charter or ratified the charter. I also know today that when there is a country that would like to become a member of the Council of Europe, the country, first of all, has to sign and ratify the humanitarian charter. It should be a prerequisite, I understand that. But let's never forget that all of these conventions have to be ratified in some countries, and there are many, charters and conventions that were ratified at the Council of Europe, but not all of them are ratified in the countries themselves, and not all of them become law in the countries in question. Now, on to your second question, when you talked about street children who are homeless and living in the streets, I must say that I'm not familiar with this issue. We don't have the same problem in Switzerland, obviously, but I would like to give you an indirect answer, because what Mr. Xavier Créach said was most interesting, I think. He described an interesting approach. He said that we always have to repatriate, quote unquote, the child and reunite them with their parents. Now, I would like to say that I'm a bit disillusioned, a bit more disillusioned than I was at first. Well, that's what I heard. That's what I thought you said, that we have to unite families. We have to bring them together, not repatriate them. I said that they should be together. Okay, sorry, it's my French, says the speaker. No, I mean, we should have this family reunification. That's very much in everybody's, in the spirit of this discussion and in everybody's mind. The kids need to be reunited with their families, but sometimes it's very difficult to understand whether the child is a refugee, is a fully fledged refugee. In other words, is he a refugee from Syria or fleeing a war, a conflict? Or isn't this a child coming from a country, as you mentioned, coming from Burundi, from Chad, where children can be rejected by the family, and their life can be at risk because there are so many children, and the family will pay, in fact, for criminals to take this child to bring him to Europe on a boat. So, ladies and gentlemen, do not forget this. This is also a truth that we have to face, and here the only answer we might have is, to try to curb the level of poverty in these countries. That's number one. And secondly, we have to help towards the economic development of that country. Listening to what Xavier Créach said, I was really most impressed when he said that at the end of the day, we should have... We should, first of all, make sure that these people have received an authorization to remain in Great Britain. Let's not forget about the Brexit. Let's be very careful. Let's not be overly idealistic. You have to look at the reality on the ground in the different countries. Keep that in mind and balance that against your illusions. And I must say that I haven't yet found an answer to that question.
Merci, Madame Fiala.
Thank you, Mrs. Fiala. Xavier. Yes, I would like also to answer the question on the humanitarian visas, if I may. There was a question on that. Well, first of all, when I talked about England, I didn't talk about being idealistic. I talked about children who had a right, according to British law, to the current British law, to family reunification. They have a right to that. So these people, the 700 children who managed to rejoin their families in the UK, this led to no status, to change in their status. They had a right. They were fully entitled to do that. Nobody had helped them, in fact, to implement the procedures of family reunification or to solve the pending problems, for example, spelling their name, establishing the family ties, etc. But these were people who were entitled to that. So it's not like saying that everybody will be enjoined to to do this. Some of these children have a right that is already enshrined in the legislation of a great many countries, and they have a right to family reunification as of now. So all you have to do is implement this right, help them enforce this right, finding the father, finding his address, finding the family link that links the child to the family. On the humanitarian visas, yes, if you talk about the legal pathway, you're talking about a legal avenue. So it could be your family reunification, it could be humanitarian visas, it could be resettlement. Some people call this humanitarian transfers. It could also be subsidy to study, for example. We are in a context that we know, and we don't say it in so many words, but there are great many visas that are given. But for obvious political reasons, the leaders of the different European countries don't necessarily want to mention this. Last year, 70,000 labor visas were delivered to Senegalese workers, for example. So yes, already a number of visas are already delivered. There are already available forms of help, because sometimes we need labor because we need to recruit students and so on and so forth. So that was the purpose of my presentation. Maybe I wasn't understood, but we have to rely on the existing options. Even if they are insufficient, at least they exist, but they're very difficult to operationalize, to implement. For a child on his own, I don't know, somewhere in Europe or in Northern Africa, it's very difficult to implement a family reunification procedure with his father, mother, other members of his family. It's almost impossible to do, even though there is a right for the child to do so. But it's very difficult to operationalize and to implement this right. I'm very sorry, I didn't understand 100% your message. I didn't understand what you were trying to say 100%. I agree there. But I would like to tell you that in Switzerland, for example, every child, every adult has a lawyer by his or her side to get some help, to get some assistance, to find the right person, to locate parents, family members, and so on. And now we have centers under the same roof where everybody will work together, different services working together to find the solution and locate the parents very rapidly. This is in Switzerland, and it was highly and harshly criticized in Switzerland. UDC was against it, for example. Some lawyers, trying to help the parents and help the affected persons. A lot of people were against them, but I think it's really the only way of being swift on your feet to, operationalize the reunification of families.
Thank you very much for this discussion, although it was a little bit of dialogue within the panel, but nonetheless, I think it was quite interesting. But now I think that the top question actually is addressed to Adriano, and it's a very legal question. Do you see any discrepancies in the European Court of Human Rights and the Court of Justice of the European Union case law on asylum and return proceedings, in particular in regard to detention? Adriano.
Right, thank you for the floor, and I maybe also can react to a couple of other points that were raised in the questions that were posed. First, I think that the logic when it comes to the privation of liberty of the UN system, the Council of Europe system, and the EU system when it concerns immigration detention is a bit difficult to combine and make coherent. So there are a number of open questions that I also have, but what I would like to say is that the European Law Institute just very recently, a couple of weeks ago, published a tool, in fact, a tool for judges. It's called Standards for Deprivation of Liberty or for Detention for immigration purposes, with 3 parts, one on asylum seekers, one on Dublin detention, and one on return directive detention, that actually goes in a very minutious way in examining the relationship between the judgments of the 2 courts. So for those who want to have more details, I refer to that wonderful piece of work that has been done by an excellent team of lawyers. There are, however, tensions. One is that the courts in Luxembourg and in Strasbourg need, of course, to build on their own legal system. And the 2 legal systems are, in my view, not necessarily easily to interconnect. One example, I think, or for me the most illustrative example is the possibility to detain a person, an asylum applicant or an applicant for international protection for reasons of national security or public order. As such, I find difficulties to frame this in terms of Article 5.1 of the European Convention of Human Rights. I mean, there are probably much better experts of the Convention here in the room, so if I'm mistaken on this, I'm happy to learn more. And the other thing is the challenge between, when it comes to detaining as applicants for international protection at points of entry, where the protection system that the EU asylum acquis provides ensures to persons who submit an application and lodge an application for international protection to stay in the country lawfully. So to what extent can you speak of unlawful entry in this context? So in that sense, there are frictions and that the judges in the two courts would need to iron out in the cases that are coming, and we will see how that challenging task in a way will be managed. What I would like also to react to is there was a question basically, what can we do to have more states that prohibit immigration detention of children? And I think here the key from our point of view is really to operationalize the safeguards that already exist in European law, so both Council of Europe as well as European Union law, in practice. I mean, the second slide, I think, that I showed with the 5 boxes, maybe I didn't underline it very much or sufficiently, where you look at legal basis in national law, the grounds, the proportionality and necessity assessment, the procedural safeguards, the conditions. Each of these boxes, on each of these boxes, you need a number of requirements. You need to be able to tick a number of requirements to allow or for immigration or for deprivation of liberty to be lawful, not to be arbitrary. And as some officials have put at us, in one member state we recently visited, the reaction was just, well, it's just too cumbersome to apply all these safeguards. We rather don't detain unaccompanied children because it just takes too much effort to go through this process of justifying each individual step. And I think in a way, that's what is not done. In practice, we have a lot of safeguards. They've been highlighted in the course of today that would reduce, that if applied correctly, immigration detention of children will really, really be exceptional just for very, very exceptional cases, contrary to what it is today, which is some sort of almost default solution in member states, or in some member states at least. Let's take the example of France. I mean, we heard this morning about all the French cases in front of the European Court of Human Rights, very progressive cases. But let's go and look at the number of kids in detention in France now. Have they diminished? Is the number lower? No. On the contrary, I mean, from what we hear, it seems to be more children in detention than in the past. So I think there is a big challenge there, but the implementation, the proper implementation of the safeguards will make it difficult to actually apply detention systematically, and or apply detention in frequent situations as it is now the case. And when member states realize that there are other ways of handling of resolving the migration situation of certain groups of people which take less effort from their side by applying alternatives or other ways, I mean, that will then work, and then immigration detention will become, in a way, not necessary and not used anymore. There was also a question, if I can just take 1 minute, put by someone, to what extent should there be specialized judges that review or that approve immigration detention of children. So should immigration judge, should there be some sort of child immigration detention judges, in a way, if I understood correctly, that approve the decision of depriving a child of liberty. I think the view we have taken is that it is useful to involve the national child protection authorities. So national child protection authorities are in most cases not at all involved with immigration detention of children, or very rarely involved with immigration detention of children. For example, in Estonia, where the child protection authorities visits when there is a child in detention. But in the procedure running up to the detention decisions, the only example we could see was the example of Southeast Finland that I was mentioning before. So rather than specialized judges, involve the child protection authorities. And there was also another question whether we take into account in the study de facto detention. So as such, the study or the comparative report that they just presented is broad, covers all forms of deprivation of liberty, regardless of how they are termed under national law. But then, of course, some parts of it zoom in more on certain types of detention and not on others. So, for example, when it comes to the detention conditions, we had very little information on temporary facilities being used at border crossing points, for example, for immigration detention or deprivation of liberty of newly arrived immigrants. But we did touch upon examples from the hotspots or from the first reception centers, for example, in Taranto, in Italy, or in Greece. And we also have additional material. In 2014, we issued 2 reports on, 2013, sorry, on the situation at airports and the situation at land border crossing points, where we also touched upon the situation of how children are dealt with, and which also cover the specific situation of detention at border crossing points. So the report itself zooms in primarily on the classical immigration detention facilities, because that's where we had most of the information on, but the analysis includes all forms of immigration or deprivation of liberty for immigration detention. Thank you.
Thank you very much, Adriano. There's one more question about the Parliamentary Assembly.
Yes, I would like to answer in the following way. We invited the Croatian judge for juveniles. This is one example. And then we also invited the European Court of Human Rights. And we have several times invited experts in the field. And this was very interesting. And but then again, I would like to say we had examples how specific countries would have legal assistance or judges, but whether this will be brought to the countries, back to the 47 countries of the Council of Europe, it's very difficult to say. It all depends on the motivation and the speed also of our parliamentarians. So we can offer a lot of instruction and a lot of knowledge, but then at the end, it's really in each country that the people, the parliamentarians and politicians must act.
Thank you very much. If I may just add that the Council of Europe has produced a training module on asylum under the Human Rights Education for Legal Profession, which is addressed to judges, and it is available in some languages, depending on which asks for it. We develop it together with the High Commissioner, with the UNHCR. So this is available online, and it provides information on detention and the case law of the European Court of Human Rights, built on also on domestic legislation, so to make the link between the two. Xavier.
I would be extremely brief. I mean, because I saw the time running, I didn't say one of the main points of what I wanted to say. The problem we have seen is that we call HCR and many others for legal pathways to be developed. But of course, it's not the trend in Europe. The trend in Europe is to limit family reunification. And as I said, if you limit family unification, you encourage smuggling and trafficking. You encourage people to cross illegally border. I want to take a very specific example. You know that if I make a simple distinction, there are two main ways to protect refugees, the 1951 Convention, and another one which is called subsidiary form of protection. Sometimes they call it humanitarian asylum, sometimes they call it, but it's subsidiary form of protection. Many governments have introduced a prohibition to family reunification for people who are granted subsidiary protection. Switzerland is one of them. So we have people who are recognized as having a protection need. They are given a resident status in one country, but without the possibility to bring their kids or their spouse. This creates the problem we're talking now. And also, it's a real problem because the main factor to integration is family reunification. It's extremely difficult for someone to integrate into his new country society if he's not with his family. So the fact that more and more governments in Europe are restricting family reunification has a direct impact on the discussion of today, but also will create very serious integration problem for the reason I said, extremely difficult to integrate without your family by your side.
Our time is up, I've been told. I would just like to say, as a small conclusion from our session, that we've heard a number of arguments that lead indeed to show that there are good reasons to end the migrant children detention. I think that what we should say is that short-term benefits, whether they are political, social, financial, electoral most of the time, that the state may take by using or resorting to migrant child detention, are completely outweighed by the damages that immigration detention causes, not only to the children, but also to the people, to our societies, to the credibility of the rule of law, to the credibility of human rights, to the credibility of our institutions, and ultimately to the credibility of our democratic societies. And this is precisely what the Parliamentary Assembly, the UNHCR, the Fundamental Rights Agency, and the Council of Europe, of course, try to do in their work with the political deciders. So thank you very much for the participation, for being so active. Thank you to the panelists for their extraordinary insight, and enjoy the reception.